Hey, good day. Roger Martin from Billings, Montana. What Jay Sekulow says is so important that it should be basic constitutional law 101. Listen to this.
Constitution of the United States. One manager said that it is you that are on trial, the Senate. He also said that, and others did, that you're not capable of abiding by your oath. And then we had the invocation of the ghost of the Mueller report. I know something about that report. It came up empty on the issue of collusion with Russia. There was no obstruction. In fact, the Mueller report, to the contrary of what these managers say today, came to the exact opposite conclusions of what they say. Let me quote from the House impeachment report at page 16. Although President Trump has in times invoked the notion of due process, an impeachment trial, an impeachment inquiry is not a criminal trial and should not be confused with it. Believe me, what has taken place in these proceedings is not to be confused with due process. Because due process demands, and the Constitution requires, that fundamental fairness and due process, we're hearing a lot about due process is designed to protect the person accused.
Exactly. Quote unquote, due process is to protect the individual who is accused. That was not done by the Congress or the House of Representatives.
When the Russia investigation failed, it devolved into the Ukraine. A quid pro quo. When that didn't prove out, it was then bribery or maybe extortion, or somebody said, one of the members or the members of the House said treason. But instead we get two articles of impeachment. Two articles of impeachment that have a vague allegation about a non-crime allegation of abuse of power and obstruction of Congress. Managers, right here, before you.
Schiff, because he was part of the process in the House and is a possible witness, should excuse himself from this proceeding. But he's not. This is another due process, which is messed up. This is another legal situation, a quandary, which is messed up. And it sets a very bad precedent.
Today, who have said that executive privilege and constitutional privileges have no place in these proceedings? On June.
Well, isn't that about as treasonous and un-American as you can get? Good grief.
June 28, 2012, Attorney General Eric Holder became the first United States Attorney General to be held in both civil and criminal contempt. Why? Because President Obama asserted executive privilege. With respect to the Holder contempt proceedings, Mr. Manager Schiff wrote, "The White House assertion of privilege is backed by decades of precedent that has recognized the need for the President and his senior advisors to receive candid advice and information from their top aides." Indeed, that's correct. Not because Manager Schiff said it.
He's one of the biggest liars there ever was. And deceivers. But historically, he's correct.
But because the Constitution requires it. Mr. Manager Nadler said that the effort to hold Eric Holder, Attorney General Holder, in contempt for refusing to comply with various subpoenas was, quote, politically motivated, and Speaker Pelosi called the Holder matter, and I quote, a little more than a witch hunt. What are we dealing with here? Why are we here? Are we here because of a phone call? Or are we here before this great body because since the president was sworn into office, there was a desire to see him removed. I remember in the Mueller report,
That is a great question. And historically, they're going to show in the past 3 years that that is pretty correct. He states that here in a moment.
there were discussions about, remember, insurance policies. The insurance policy didn't work out so well. So then we moved to other investigations. I guess you would call it reinsurance or an umbrella policy. And that didn't work out so well. And here we are today. Manager Schiff quoted the Supreme Court, and I'd like to make reference to the Supreme Court as well. It was then Justice Rehnquist, later to be Chief Justice Rehnquist, who wrote for the majority in United States versus Russell in 1973. These are the words. We may someday be presented with a situation in which the conduct of law enforcement agents is so outrageous that due process principles would absolutely bar the government from invoking judicial process to obtain a conviction. That day is today.
Wow, what a statement. You need to replay that back. What a statement. Way to go, Jay. Way to go.
That day was a year ago. That day was in July, when Special Counsel Mueller testified. I am not today going to take the time to review, and I will do it later, the pattern and practices of irregularities that have gone on in these investigations from the outset.
Irregularities, quote unquote. Irregularities. I'd say criminal irregularities.
But to say that the courts have no role, the rush to impeachment, to not wait for a decision from a court on an issue as important as executive privilege, as if executive privilege hasn't been utilized by presidents since our founding. This is not some new concept. We don't waive executive privilege. And there's a reason we keep executive privilege, and we assert it when necessary. And that is to protect the Constitution and the separation of powers.
To protect the president and the separation of powers and the Constitution. Interesting. Protect the Constitution, he said. But I think you'll find out it's more than that.
The president's opponents, in their rush to impeach, have refused to wait for complete judicial review. That was their choice. Speaker Pelosi clearly expressed her.
Now, why would you do that? Why would you think that you're above the law and you don't want the courts involved when this whole process is going to have the Supreme Court involved? The head justice. Crazy.
Her impatience and contempt for judicial proceedings when she said, "We cannot be at the mercy of the courts." Think about that for a moment. We cannot be at the mercy of the courts. So take Article 3 of the United States Constitution, remove it. We're acting as if the courts are an improper venue to determine constitutional issues of this magnitude. That is why we have courts. That is why we have a federal judiciary. It was interesting when Professor Turley testified before the House Judiciary Committee in front of Mr. Nadler's committee. He said, we have three branches of government, not two. If you impeach a president, if you make a high crime and misdemeanor out of going to courts and abuse of power, it's your abuse of power. You know, it's more than that. A lot more than that. There's a lot more than an abuse of power if you say the courts don't apply. Constitutional principles don't apply. Let's start with a clean slate as if nothing happened. A lot has happened. As we proceed in the days ahead, we will lay out our case. we're going to put forward to the American people, but more important, for the Constitution's sake, what's taken place here. But this idea that we should ignore what has taken place over the last 3 years is outrageous. We believe that what Senator McConnell has put forward provides due process, allows the proceedings to move forward in an orderly fashion. 33 days. 33 days they held on to those impeachment articles. 33 days. It was such a rush of national security to impeach this president before Christmas that they then held him for 33 days. To do what? To act as if they negotiate, the House of Representatives should negotiate the rules of the United States Senate. They didn't hide this.
They have no authority, legally or otherwise, to negotiate the rules of the Senate. They're representatives of the House. They're not senators. There's no voting voice in this. The managers don't get to vote on this. The senators do. And the decision is going to be made by the Chief Justice.
This was the express purpose. This was the reason they did it. We're prepared to proceed. Majority Leader, Democratic Majority Leader, we're prepared to proceed. In our view, these proceedings should begin. I yield the rest of my time to my colleague, the White House counsel. Thank you, Mr. Chief Justice.
Sekulow.
Thank you, Mr. Chief Justice. I just want to make a couple of additional points. It's very difficult to sit there and listen to Mr. Schiff tell the tale that he just told. Let's remember how we all got here. They made false allegations about a telephone call. The President of the United States.
Now they're going to end that. But Jay Sekulow really says it well. Let's see what happens before the day's out. They have 24 hours. I don't know how much this will go on during the night. Evidently, it has been accelerated, and the managers have given their presentation. The President's Counsel has pretty much given their presentation. So this has been accelerated. Let's see what happens here in this next several days. It's Roger Martin from Billings, Montana. Pay attention to what is being talked about. Constitutional law, due process, other things. You have to use the courts in this. This is a real trial, but it's the trial of the highest position of political power, the President of the United States, to be removed from office. To be removed from office. All right. And there's only been 3 presidents that have been impeached. One has been removed from office, I believe Nixon. I don't think Clinton was removed from office. But they held a trial. And Trump, I don't believe, will be removed from office. All right, it's Roger Martin from Billings, Montana. Good day.